appeal in the matter of Cutrale Jr., represented by Mrs. Rosana Falcioni and another, Ruiz Sanches and others.
Mr. Kennedy.
Good morning. My lords, I appear for the defendants, Mr. Luckhurst and Mr. Fletcher. My other friends, Mr. Chu Choi, KC, Ms. Wells and Ms. Kazamali appear for the claimants. By way of housekeeping, you should have four skeleton arguments, a core bundle, a supplemental bundle, and 4 bundles of authorities. And there is a separate slim Ladin-Marshall application bundle.
Now, this one has not reached me. I mean, it did come through by email. I'm afraid that I thought I'd wait to see the hard copy, and I haven't yet seen a hard
I'll
copy.
make sure that my lord gets a copy of that. I won't be turning to it until shortly before lunch, and so I'll make sure that you have a copy of it.
Thank you very much.
As the court has seen, there are 2 appeals before your lordships, and we have agreed an approach between ourselves, subject to the court, as to how to address them. In summary, the defendants will go first. I will open grounds 1 and 2 of our appeal, and the claimants will reply today on grounds 1 and 2, and their reply will stretch into tomorrow. Then my learned friends will open the claimant's appeal on all grounds, and that will stretch into the 3rd day. And in my reply to the claimant's appeal, I will open our 3rd ground of appeal. Then the claimants reply on their appeal, and I will have a very short reply on my ground 3. The precise timing for each of us is still in discussion. Suffice to say, we have the court's indication that you will finish at 4:15 every day, and we need to finish the appeal within the 3 days, with the time divided equally between us.
Sounds very sensible. Thank you.
Subject to the court, then, I propose to get straight into grounds 1 and 2 of the defendant's appeal. And I'll begin with ground 1. And I'll summarise, if I may, our arguments and then turn to the authorities. Ground 1 of the defendant's appeal concerns the claims added to the Viegas Claim on the 22nd of November 2019 and the 23rd of January 2020. And as the court has seen, the claimants for these amendments relied on CPR Rule 17.1 alone, because they were amendments made between the issuing and serving of the claim form. And the defendants relied on Rule 17.2(1) to ask that these amendments be disallowed. Now, there's no dispute between the parties that the defendants had and have an arguable case that limitation had expired in respect of those new claims. And we argued before the judge that where there is an arguable case that limitation has expired, the amendments adding the claims in question should be disallowed, unless the claimants can fall within the exceptions in Rule 17.4 or 19.6. But the judge disagreed and found there is an additional requirement that must be satisfied if such an amendment is to be disallowed. She found that the defendant's limitation defence to the new claim had to be specifically prejudiced by the operation of relation back under section 35(1) of the Limitation Act, and that the prejudice had to be assessed by reference to the defendant's pleaded case only. And so the judge held, this is the crux of the learned judge's finding, if a defendant had pleaded that the original claim was time barred, giving the new claim the benefit of relation back would not cause the defendant any prejudice. If the defendant was right, she found that the original claim was time barred, that would also serve to knock out the bit of the amended claim that extended back. So on the judge's analysis, the necessary prejudice would arise only where the defendant had no pleaded limitation defence to the original claim, but did have one to the new claim added by the amendment. And we submit that this additional requirement significantly relaxes the test for allowing new claims to be added by amendment when they are arguably time barred. This, we say, is contrary to the language and purpose of section 35(3) of the Limitation Act, which is the basis for the jurisdiction. We say the authorities relied on by the learned judge do not support this requirement for prejudice, and to the extent that earlier authorities do appear to support the claimant's case, they have been superseded. Finally, in any event, the defendants would be prejudiced if the amendments were allowed. And we say that the judge was wrong to find otherwise. Because we say when limitation is in issue in a case, the court is not restricted to finding that time has expired on the particular date pleaded by the defendant, or not at all, as the claimant pleads. The court may well find that the limitation period expired sometime later than the defendant pleads or the claimant contends. And that is especially possible where deliberate concealment is alleged, as in this case. The court needs to work out when the claimant, with reasonable diligence, could have recognised that they had a worthwhile claim and began the preliminaries necessary for issuing a claim form. When limitation is an issue, a new claim may well get an advantage from the operation of relation back, compared with being raised in a new action. If the court settles the date for the expiry of the limitation period sometime between the date of the original claim form and the amendment, regardless of what the parties have pleaded, relation back will save the new claim, which would otherwise be defeated if issued in a new action. And that is, we say, concrete prejudice. That risk or possibility is concrete prejudice, and the potential for it arises whenever limitation is an issue. That, in a nutshell, is our argument on ground one. With it then, subject to the court, I'll go straight to section 35 of the Limitation Act itself. And that is in volume 1 of the authorities volume. Tab 7. Sorry, tab 3. Tab 3, page 7. The court has first section 35(1), which provides for relation back. Forgive me, this is obviously very familiar ground to the court. I'll pass over it quickly. Any new claim made in the course of any action shall be deemed to be a separate action and to have been commenced, B, in the case of any other new claim on the same date as the original action. And then section 35(3), except as provided by section 33, which is immaterial for our purposes, or by rules of court, neither the High Court nor the County Court shall allow a new claim within subsection 1b above, which we've just seen, skipping ahead, to be made in the course of any action after the expiry of any time limit under this Act, which would affect a new action to enforce that claim. So, a new claim shall not be given the benefit of relation back if in a new action it would be time bound. And that is a statutory prohibition, and it's been implemented in the Civil Procedure Rules. And for a summary of how they operate, I'd ask you to go first to the White Book. I propose, subject to the court, to go to the White Book and then to the authorities in reverse order, beginning with the latest. The White Book, the 2024 edition, volume 1, page 525.
I have brought into court my 2024 White Book. We don't routinely now have in court the up-to-date editions of the White Book, so I suspect my Lord Justice Lewis has an older white book.
I've got an older version because I didn't bring the 2 volumes of the 20.
I'm very sorry. I was wondering. I did wonder if that would be the case. Oh, we have Mr. Luckhurst. Well prepared has gone.
I'll bring it after lunch, don't worry.
So it's page 525 and the commentary, paragraph 17.4.2. And the heading, resolving disputes as to whether a limitation period has expired. Where it is reasonably arguable that the relevant limitation period has expired before an amendment is made, the burden is on the applicant to show that the amendment falls within the provisions of Rule 17.4 or 19.6. And skipping down below the indented passages and below the reference to Alame and Shell, I take it up where the sentence begins, a new claim under section 35.3 is not made until the statement of case is actually amended, which by definition cannot be earlier than the date upon which permission to make specific amendments is given. Unless the case falls within one of the exceptions, such permission cannot be given after the relevant limitation period has expired. Skipping down to the next paragraph, where there is a dispute as to whether or not a new claim sought to be raised by amendment is statute barred, the claimant must prove, 1, that the defendant's limitation defence is not reasonably arguable, or that, in any case, the amendment falls within the provisions of Rule 17.4 or 19.6. If they cannot establish either 1 or 2, permission to amend should be refused, leaving the claimant to bring fresh proceedings on the new claim. And for that, we see cited Chandra and Brook North, which I'll come to, and Ballinger and Mercer, which unfortunately was not in the authorities bundle, but we will hand a copy up when I come to it in my submissions. Then Cameron, Taylor Consulting and BDW Trading, the Court of Appeal considered both Rules 17.4 and 19.6 and iterated that common to both was a need to decide whether it was arguable that limitation had expired. And the indented passage is, if a defendant can show that it is reasonably arguable the new claim introduced by the amendments is statute barred, then leave to amend should not be given. Leave to amend will be given if the claimant can show that the defendant does not have a reasonably arguable limitation defence. And there is no reference there, we note, to the additional prejudice requirement as identified by the learned judge. There is a reference, though, to our case at first instance in the next part. In Viegas and Cutrale, the court rejected a submission that authority since Chandra had limited its application and defendants only had to show that they had a reasonably arguable limitation defence for the court to disallow the claimant's amendments. In my submission, that reference is hard to follow. Where Rule 17.4 and 19.6 apply, it's plainly not sufficient. But I can't say much more about it. It's hard to understand precisely what's meant in that passage. My short point here is that in the summary of the cases on the applicable principle, if the judge was right that there was this quite important limitation on the test for disallowing amendments, one would expect to see it there. But turning to the authorities, I'll begin, if I may, with the latest Cameron Taylor, and that is in volume 4, tab 47.
That passage you showed us
Yes.
is obviously written with the case of an application to amend in mind.
Yes.
Our case is slightly different because these are pre-service amendments and it's an application to disallow.
Indeed, my lord. And
Is it common ground the same principles apply?
well, certainly I proceed on that
That's
basis.
that's your submission.
Yes.
Yeah.
Yes.
And you don't understand that to be disputed.
No, indeed.
My lord is not. And I'll explain why later, if necessary.
But I take my lord's first point, which is that the focus in that passage is on 17.4 itself. I don't suggest that it's a comprehensive.
There is one potential difference. As that passage shows, if you apply to amend, and it takes some time for the application to come before the court, you don't actually amend until the court says you can, and then you amend. And
Yes.
that's the relevant time
Yes.
for consideration of whether the limitation bites or not.
Yes.
But in this case, presumably the amendment is made when it's made, and that's when the limitation point bites, not when the application to disallow is heard.
Indeed. Indeed. In our submission, that would not make a difference to the points that we will
No, I understand.
to the court. That doesn't affect the points we'll make to you.
Thank you.
Cameron Taylor itself, tab 47, page 1285, paragraph 1, to introduce the case. Lord Justice Poulsen, this appeal raised issues as the application of Rules 17.4 and 19.5, the amendments and the substitution of parties following the possible expiry of a relevant limitation period. And if you could turn please to page 1286, you see the relevant dates, paragraph 5. On the 6th of March 2020, the claim form was issued. And that's important because that date will show you that there was in this case, a general limitation defense. Then paragraph 6 to 7, you see the amendments. There's an amendment from 17th of March 2020, it's the claim form, and then paragraph 7 on the 18th of March, re-amendments to add claims against the defendant. And paragraph 9, we see that the defendants issued an application to disallow the amendments and re-amendments. If you go please to page 1288, paragraph 24, the issues on appeal. The first part of the appeal arises out of the defendant's unsuccessful application to disallow the amendments on the 17th and 18th of March. And counsel for the defendant submitted it was reasonably arguable that the relevant limitation period had expired by the time the amendments were made. And she said the judge applied the wrong test in law, and had he applied the right test, he would be bound to hold that the 15-year limitation period, that was the long stop, the negative time limit, had at least arguably expired. One sees right away, my lords, that on that basis, a 15-year limitation long stop, you will see when we come to the facts itself, would have knocked out the original claim form as well as the amendments. But we'll see that when we look at the facts later. 1291, please, page 1291. Paragraph 34. The relevant authorities. The starting point in considering the interplay between limitation arguments and amendments is Welsh Development Agency and Redpath Foreman, where the Court of Appeal upheld the earlier decision of the referee refusing the proposed amendments concerned with negligent misstatements. In an important passage, Lord Justice Glidewell said, we now wish to make it clear that although the test applied in Leicester Wholesale Fruit Market and Grundy was the correct test in the circumstances of that case, in which Section 35(1) gave the plaintiff no advantage, it was unnecessary for the decision in that case to disagree with what Justice Purchase said in Grimsby Coal Stores. I'll come back to that case later. Our view is that Judge Hicks was correct in concluding that where Section 35(1) does or may well give the plaintiff an advantage, a different test, namely that enunciated by Lord Justice Purchase in Grimsby Coal Stores, should be applied. In such a case, leave to amend by adding a new claim should not be given unless the plaintiff can show that the defendant does not have a reasonably arguable case in limitation which will be prejudiced by the new claim. And paragraph 35, he addresses the question of whether anything has changed because of the civil procedure rules. He notes that WDA was decided under the old rules, but there's no substantive difference between the old rule and the CPR. And as Lord Justice Jackson pointed out in Chandra, the guidance in WDA is still directly applicable to the CPR. And then Chandra is cited. And I'll read, if I may, the indented passage. It'll save us reading it in Chandra when we come to it. And my point here again is, in this passage, one doesn't see the extra requirement for specific prejudice of the
Isn't
type.
that because it simply didn't apply on the facts in Chandra, and therefore they didn't need to refer to it because it was either all in or all out, whatever the date of the amendment in Chandra.
The particular point wasn't argued in Chandra. You're quite right, my lord. In Chandra, the point didn't arise.
Yeah.
All I can say is, if it were part of the test, one might expect to see a reference.
But if they were setting out a test as opposed to adjudicating on the case in front of them, saying,
Indeed.
Can I go back to the passage you cited from Welsh Development Agency via paragraph 34 of this? Justice Glidewell says Leicester Wholesale is the correct test in that case in which section 31 gave the plaintiff no advantage, and then he distinguishes between that and the case where section 31 does or may well give the plaintiff an advantage.
Yes.
Is that the same question we're discussing?
It is. Well, indeed. It looks like the very same question that we're discussing.
In which case he's distinguishing between two types of case, and WDA he puts in the second box. And then when Chandra says WDA still applies, why is that not also limited to the second box, where section 35(1) does or may well give the plaintiff an advantage?
It really depends on what's meant by giving an advantage.
Yes, I see.
And
Well, that we will need to unpack that at some stage.
yes,
But don't do it now if you're going to do it later.
indeed. I really am. The short point, that's a key point, and I'll come to it because I need to show you Grimsby cold stores as well.
Yes.
it's almost better to do them in chronological order, isn't it? Because then you know what they were saying and what they were deciding. Because Cameron and Taylor is reacting to that, whereas what you're trying to do is embodiedly create a test, and you're arguing, is it this test or that test? And the words in this case support one or the other. And in a way, that's not the way it's evolved, but anyway, it's a matter for you.
I think I can get away with what I'm doing, provided I don't overstate what can be taken from the authorities. And that's why I'll stick to my approach without overstating that. So my lord's quite right that in Chandra, the point didn't arise because there was no general limitation defence. My short submission was that if, maybe good or bad, but if one had this important element of the test, one might have expected to see it in Chandra. But the test in Chandra, the test which the court decided to set out in Chandra for its purposes, is set out in those indented passages, and they restate. I shan't read it to you. The court's obviously familiar with it. The summary which you saw in the White Book. On WDA, if the question is, what does this case do with WDA? It's my submission that the court didn't need to engage with whether WDA has the effect for which the judge found and my learned friends contend. And part of the importance of WDA in this case was to re-emphasize the fact that the rules hadn't changed between the RSC and the CPR. And then paragraph 45 of Cameron Taylor. The last of the dates on which there occurred any act or omission which is alleged to constitute negligence. And this is just identifying whether the limitation period had expired in that case. And the court noted that in a negligent case like this, what matters is the last date or dates on which the defendant was responsible for a negligent act or omission to which BDW's damage can be attributed. In the case about design of defective buildings, the authority holds that this happens when the relevant defective design was incorporated into the building. In practical terms, that will happen when a drawing containing the relevant defective design was issued to the contractor for construction purposes. And you go over to paragraph 48 on page 1295. The judge said, on the evidence available here, I conclude that it is reasonably arguable that the relevant drawings were issued to the contractor for construction purposes and the defective design therefore incorporated before 18th of March 2005. And skipping down 3 lines, a study of that drawing showed that it had been issued for construction on the 26th of November 2004. So the judge said there, well, obviously that's well before the limitation cut-off date for the purposes of the application, for the purposes of disallowing the amendment application. But what that date tells you is that it was also a general limitation defence, because if the 15-year long stop was applied to that date, the 26th of November 2004, time would have expired on the 26th of November 2019. And as the court saw at the beginning of the judgment, going back to paragraph 5 on page 1286, the claim form was issued on the 6th of March 2020. So on the face of the judgment itself, it was obvious that there was also a general limitation defence, an arguable general limitation defence.
I haven't properly kept up with you on this. I was looking at something else. So you say 48 shows that there was pleaded a general limitation defence.
It's not clear if it was pleaded. The judge was noting that on the evidence before him, the negligent act, the point which the judge himself says is the point for argument for counting limitation period.
And he finds on the particular facts that there is arguably the crucial date was more than the relevant period before the claim was issued.
That he doesn't need to speak of the original claim form because he's only asked to focus on the amendments.
Yes.
So he's only asking if 15 years expired.
Yes.
For the purpose of the amendments. But he's for that purpose, for finding that there's obviously an arguable case that the amendments are out of time, he notes that the negligent act allegedly took place in November 2004. And where the claim form was issued on the 6th of March 2020, the original claim form was obviously a general limitation defence to the whole thing.
Yes, I see.
The claim form as well. So again, just like our case, and if the judge's analysis is correct, one would expect to see, I fully take the point that it doesn't appear to have been argued, but one would expect to have seen that point being taken here, in this case, because on the basic facts before us as found, there was a general limitation defence to the claim form.
The court is very much bound by the points counsel choose to argue. In fact, there are limits to the extent to which the court can go off and decide the case on points that haven't been argued by counsel.
Indeed, my lord. But
so as a matter of authority, what is the status of a decision on a point which wasn't or doesn't appear to have been argued?
it cannot be authority for the proposition for which I advance. I simply note, and I will do to the authorities, that these general defences appear in the authorities, and it's never been suggested. And as I'll explain, there's a good policy reason why it shouldn't work this way. It's never been suggested that where a general limitation defence exists, the defendant gets no advantage by knocking out the amendment on the basis of an arguable limitation defence.
So I read on a bit in the next few paragraphs, 1296, they say that they couldn't, on the evidence, bring claim on the basis that some of the drawings came after the 18th of March 2005. So they're stuck with the absolute cut-off point of the 18th of March 2005. And then they go on and say because the amendment would come after the end of the limitation period, they're going to disallow it. And you're saying that's what should happen generally with the limitation period. You shouldn't say, well, it doesn't make any difference. They can amend and it'll still be covered by it. Is that your point?
That's the effect of the judge's judgment.
Yeah.
And that drives a real coach and horses through the strict approach one is supposed to take to 35.3. It means that, and one can see right away, even post-service, if a claimant can come forward and say, I'd like to add a new claim, a new party, there's no need to make an application under 17.4 or 19.6. Because even if there's an arguable limitation defence to it, provided the defendant has a general limitation defence, it will be said, well, it creates no prejudice for the defendant. And therefore, the amendment should not be disallowed.
Would that be a bad thing? I mean, if there's no prejudice, what's the problem?
Well, the problem is there is prejudice.
Well, I follow
Sorry.
that, but at this stage you're saying, well, suppose there is no prejudice, there still shouldn't be permission.
I should be more precise. There will always be prejudice. The judge's definition of prejudice is so narrow as to ignore, respectfully, the real prejudice that arises because when limitation, this is the point I made in opening, when limitation is an issue,
You can have a range of dates.
you have a range of dates.
That may be true in some cases, but in some cases it's perfectly clear that it's either date A or date B.
My lord is more experienced than I am, but in my shorter experience, when limitation is an issue, especially where deliberate concealment is an issue,
Well, I can see it with something like deliberate
well
concealment,
rearranged.
but you could have a case where there's no doubt that the claimant has suffered damage. The claimant says, I suffered damage because you broke the contract on this date. And the defence is, actually, that damage is attributable to an earlier breach of contract, which was more than 6 years ago. So it's either A or B, and there is no room for any other argument. And there, what is the problem with the judge hearing an amendment application saying, I can't decide who's right on this question. And obviously, if you can decide who's right on the limitation question, Section 33 gives you the answer, but 35 gives you the answer. But we're facing the difficulty, but you can't decide at the point of amendment whether the limitation defence is a good one or not. And in a case like that, why can't the judge say, well, it doesn't matter who's right. If the defendant's right, and it's the earlier date, it doesn't matter, because the whole claim will fail, whether the new part is in or not. And if the claimant's right, and it's the later date, it doesn't matter, because the whole claim will succeed. So what is the problem?
The problem is that because of the great advantage the relation back gives the claimant, the cases have told us, and this is authority, that it is sufficient to show an arguable limitation defence. And so,
Well, certainly where it might make a difference. I understand that entirely.
and that's the point, my lord. It might make a difference, and the word might encompasses all the possibilities that might reasonably arise in any case where limitation is raised, and that's why the courts, in my respectful submission, have adopted a rather simple test, but an effective one, which is you simply ask, is there an arguable limitation defence, and stop there.
Yes, but as I understand it, your submission is one of principle that doesn't depend on the facts as to whether it might make a difference on these facts. You say as a matter of principle, whenever the limitation, the new claim might be statute barred, doesn't matter if it's a binary case of the type I've tried to suggest or not, or
Yes.
whether it's a much more spectrum case, when should you reasonably have discovered, as a matter of principle, you don't allow it.
That's right, my lord, yes. I take the principled approach, and I seek to justify that principled approach by showing, by reference to other cases, where
Thank
the
you.
Going back to the authorities and G4S, I'm now doing what I've been told not to do. I will
We're going backwards in time.
go backwards in time. But as I say, I think it works as long as I'm honest about how it works. G4S is volume 3, tab 45. Volume 3, tab 45. Now the court will have seen from our skeleton, we're not pointing to these cases as binding authority in my favour. All I can take from them is the fact that in these cases, well, one sees either no reference to the type of prejudice which the judge says must be identified in every case for an amendment to be disallowed. And in some of these cases, you will see general limitation defences, where I say if the learned judge's point was correct, the point would have been taken, and the amendment, well, the outcome would have been different. G4S, paragraph 1168, sorry, page 1168. See the first page, and then page 1170. Lord Justice, Miss Justice Mann, as he was then, addresses the question of limitation and its interaction with the power to amend. Paragraph 16, an amendment to a claim form dates back to the date of the issue of the claim form. Accordingly, there is the potential for a claimant to amend to add to his or her claim a claim which was statute barred at the date of the amendment, but not the date of the issue of the claim form. And I obviously stress the word potential there, by reference to the risk which arises in every case with limitation. The risk that would happen. In order to meet or control that, the Limitation Act contains Section 35 and the CPR contains rules 17.4 and 19.5 which limit the extent to which such amendments can be carried out. They all refer to claims sought to be brought after the period of limitation applicable to that claim has expired. Then in many cases there will be a dispute as to whether the limitation period has expired at the date of the attempted amendment. Said by G4S, accepted by the claimants, that where there was such a dispute which affected an amendment, i.e. it's reasonably arguable that the claim is statute barred and the amendments would not otherwise fall within the privileges allowing a post-limitation amendment, the usual course is for the court to refuse permission to amend and leave the claimant to issue a fresh claim form. Again, these are statements of basic principle, and one doesn't see within it the caveat, the important caveat which has identified. Chandra and Brooke is repeated. And then in paragraph 18, in the present case, this would apply if it is arguable that at the date of any of the amendments, the limitation period applicable to the claim had expired. It would have the effect that if G4S is in a position to dispute the amendment and took the point, the amendment ought to be disallowed unless it can be brought within the exceptions provided by the rules and statute. At 19, it's necessary to consider whether there is, at any relevant date, an arguable limitation defence. G4S takes the limitation point in its defence, saying the limitation period started running in May 2013. Mr. Brady made his first announcement. It's not suggested the claimants can have known about the wrongdoing before then. It's the first date on which it can be said the claimants can have sufficient knowledge that they had a claim. And then that, G4S would say, is at least arguable with the effect that there was an arguable limitation defence as at the 11th of July 2019, which is when the first amendments were made. Alternatively, there's a good arguable case the limitation period started running on the 11th of July 2013, when the second announcement was made. So, again, if the defendant's position and the learned judge's position on limitation were correct, then the original claim, as well as the amendments, would be statute barred, because the time started running on the defence in May 2013.
Was the claim issued? Sorry.
And the 10th of July 2019.
Thank you.
You see that on paragraph 3, page 1169.
Yes.
Very first line. So we have the same situation again. Here on the pleading, there's a general limitation defence. The focus is only on the amendments. But Ms. Justice Mann didn't impose any requirement here that the defendant must be specifically prejudiced by the operation of the relation back principle.
As you say, this is simply illustrative rather than anything else, but I wonder whether actually the point even works that well illustratively, because if you read on paragraph 20, it all looks rather muddier.
Muddier, my lord, yes, but
it's not a binary choice on the face of it. The claimant's case is, well, it might be some later date.
Indeed, my lord, the claimants will very usually have, in fact nearly always have, some argument as to why that earlier date is not the appropriate date, because that, if that were true, their case would be kicked out without more. That cannot be, in my respectful submission, an answer to our point, even for illustrative purposes, which is that here, plainly on the face of the judgment, there was a general imitation defence, a defence to the original claim form, which, if the learned judge is correct, would have meant the amendments here would have been allowed instead of being disallowed.
And I follow that point, but if you look at paragraph 20, it looks as though a date in between might have been the key date, because it's about when they knew enough to justify them bringing a claim, and what about section 32?
And again, that will often be the case, and it's the case, it will be, and I'll come to this, it may well be relevant in this case. But all of this doesn't alter the fact that if the learned judge is right, Mr. Suzanne should have examined whether there was additional, because remember the point is on the defendant's defence. The point that the learned judge made was the defendant has pleaded that the original claim form is time barred. Full stop. So the defendant cannot say that the defendant has a disadvantage in allowing the amendments in, regardless of what the claimants say. The judge said in terms, do not look at what the claimant's points are, one only asks what the defendant is saying.
And that may be a good point, but if you look at the totality of the pleadings in this case, it rather looks as though there was no point in the point that you're making being run.
In my submission, that isn't good enough to save the judge's analysis, because the judge made a much more narrow finding. In fact, it supports my case, which is that once limitation is an issue, one cannot simply look at what the defendant has pleaded, or even base the decision on the claims pleaded. One has to accept that in general, the court may settle on a date for the expiry of time between the limitation period for the original claim form and the limitation period expiry for the amendments. And that possibility is the prejudice that is relevant for the purposes of this test.
I read on very quickly to 22 to 25, and it's not entirely clear what was happening and how it helped your arguments. The claimants were saying that it's possible that the limitation date didn't start running until the end of August 2013, in which case the original claim would be in time, and by definition the amendments would be in time. But the judge says he can't say that that's the position on the evidence, and then he doesn't allow the amendment. But is he not allowing the amendment, as you say, in an absolute black and white, the general 10th of July date applied? Or is he saying, because I can't rule out the possibility that there's a later date, that's why I'm not going to allow the amendment?
The judge is, from paragraph 22, is focused only on the question before him, which is there an arguable limitation defence to the amended, the new claim put in by the amendment?
And there is an arguable limitation defence, but he's also considering whether it actually has any effect. And he's saying, I can't say it's got no effect because I can't be sure the claimants are right that the date is later and it's the end of August 2013. But why is he worried about that if he's not concerned about questions of prejudice?
Because, again, from my reading of these paragraphs, the judge is testing whether there is an arguable limitation defence to the amendments. And because the defendant's case on limitation to the amendments is the same case they have for the whole claim, their arguments...
I wonder if that's true. I mean, it's clearly the case that the defendant's primary case was that even the original claim was statute barred, because it was issued on the 10th of July 2019. In their cases, limitation started running in May 2013. But that's not their only case. They have a series of fallback cases, all set out in paragraph 22. And one of their fallback cases is that the amendment actually, the cause of action actually starts running on the 11th of July 2013, which means that issuing on the 11th of July 2019 is too late. I'm not sure that's right as a matter of law, but you can see that. 5 lines down, paragraph 22, it is arguable, it's unnecessary to go further, that it started running on the 11th July 2013. And then he says at 25, it follows that the amendment debate must take place against the background that there would be an arguable limitation defence to any new claim, were that new claim to be issued on or after 11th July 2019. I think if you issue on the corresponding date, you're in time, but that's not the point. The point is the judge is proceeding on the basis there aren't just in play May 2013 and August 2013, but a range of dates in between, including one which would make amendments, a new claim issued on the 11th of July, which is the date of the amendments, statute barred. And so that's why he says this is a case which falls within what he's identified in paragraph 16 as the problem, which is the potential for the claimant to add a claim which was statute barred at the date of the amendment, but not at the date of the original claim form. And that's the problem. And since he's characterised this case as being one of those cases, and of course he applies the general principle that we see from Welsh Development Agency, and there's no answer to that to say the defendant's primary cases, the limitation period started running in May.
But the judge's approach is simply to ask if the defendant has pleaded a complete defence of the claim form. And once the defendant has said that the original claim form is time barred, there can be no question of any prejudice arising from allowing in the amendment.
That's your second point, that actually when you look at the dates, you're going to take us through the dates here. It's not just looking at the date in the terms. Even on paragraph 44 of the judge really looks if there were other dates. But that's your second point. I thought your first point is that the word is absolutely black and white. And once there's a limitation point, even if it would make no difference, because it is a limitation point that's way outside the date of the amendment, nonetheless it's not allowed. I thought that's what you're doing now.
Moulder is right. That is my first point, for the reasons that I've already tried to explain. To Lord Justice Nugee's point about the analysis undertaken by Mr. Justice Mann, I can only repeat what I said, that he's focusing on the 11th of July 2013 because that's the critical date for whether the amendment is out of time. And he says it's arguable, it's unnecessary to go further, so he only has to address that question of the date of the amendment. It's unnecessary to look more. He only has to ask if the amendment is argued out of time. It's arguable, it's unnecessary to go further, that it started running 11th of July 2013, which is sufficient for his purposes. But he says this, if not earlier. So he's acknowledging that it's perfectly possible that the time expired earlier. And I submit earlier back to the date sufficient to knock out the entire claim on the facts before him. And I do contend that if the judge was looking for the kind of prejudice which the judge says must be examined in every case, must be searched for in every case, Mr. Justice Mann would have said so. That would have been clear on the face of the judgment. On the contrary, although there's a general limitation defence, that's not his focus.
Thank you.
My next case is Ballinger. You saw it cited in the White Book, but it's not in the authorities book, I'm sorry to say. And I will hand up copies.
Very much.
So, paragraph 1 on page 3601 of the report. And paragraph that tells you the issue in dispute. Again, it's a case like the others concerning the disallowal of disallowing amendments and 17.4. Paragraph 6, please, on page 3602. again, one sees the claim form issued on the 3rd of July 2012. 3rd of July 2012. And paragraph 7, we see what was an issue in the case. There were 3 allegedly negligent valuations up to 2001. And if you go to paragraph 9 over the page, we see that the defendants pleaded a defence, and they pleaded a general imitation defence. The defendants contended that any alleged cause of action for negligence is time-bound. So they had a general imitation defence that the whole claim, the original claim form, was time-bound. They asked about the knowledge of the claimants in an RFI, and the claimants said that the earliest they could have acknowledged the 31st of August 2007, and that's obviously relevant for the 3-year period in negligence.
Sorry, I wasn't keeping up. Where do we find that?
That is the very bottom of page 3603.
I see, yes. Yeah.
Paragraph 11, over the page, the claimants applied to amend a particular claim. And paragraph 12, we see they sought to add some later allegedly negligent valuations. And paragraph 17, skipping ahead, in opposing the amendments and saying they were argued out of time, the defendants relied on their general limitation defence. The time had been barred from August 2010. The defendant's position, 2 lines down, before the judge was and remains that given the claimant's response to the request for further information, skipping ahead, the contested claims must have become time barred in August 2010. And the court will recall that the original claim form was issued in July 2012. So, moving on then to paragraph 20, that was all contested by the claimants. And at paragraph 21, we have the analysis on limitation by Lord Justice Tomlinson. And the question is, was in principle an explanation given by...
What did the judge below do? So the claimant said that that was wrong. And what did the judge actually hold?
You see that at the bottom of page 3606. The judge held that they had a reasonably arguable case, the defendants, that the new claims in certain categories are all statute barred.
Okay.
That limitation, the judge put it in the indented passage of paragraph 21. If the claimant had knowledge relevant to the repeated claims relating to the earlier evaluations in August 2007, it's unexplained why they could not have acquired the same knowledge in relation to the later evaluations. He's asking if there's a reasonable limitation defence for the later evaluations, but the other ones referred to in the amendment. And if you skip the passages that follow, it's just detail, you get to paragraph 25. It must be borne in mind that the context of the debate is the doctrine of relation back introduced by section 35(1) of the 1980 Act. If a new claim is permitted by way of an amendment, it is treated as having been made by a separate action commenced on the same date as the original action. So where an amendment is permitted to introduce a new claim which is in time at the date of commencement, but arguably out of time on the date on which permission to amend is granted, the defendant is thereafter precluded from reliance at trial on the arguable limitation defence. And there's reference to Chandra. And then at paragraph 27, he asks, on whom lies the burden of persuasion? And provided the defendant can show a prima facie defence of limitation, the burden is on the claimant to show that the defence is not in fact reasonably arguable. The claimant is, after all, in effect inviting the court to make a summary determination that the defence of limitation is unavailable. If the availability of the defence of limitation depends on the resolution of factual issues which are in dispute, can't be determined summarily, must go to trial, hence it can only be appropriate at the interlocutory stage to deprive a defendant of prima facie defence of limitation if the claimant can demonstrate that the defence is not reasonably arguable. Full stop. And that's that's again the judge's summary of the test that has to be applied. He repeats then after that Welsh Development Agency in the reference to where relation back does or may well give the plaintiff an advantage. And in paragraph 29, if a defendant can raise a prima facie defence of limitation, the judge should only conclude that the proposed amendments are not outside the limitation period if the claimant can show that the defence is not reasonably arguable. Over to page 32. In my view, the judge's approach to the limitation question was impeccable. Skipping down, the claimants did not show, and in my view, do not come close to showing that the defendants have no reasonably arguable limitation defence to the new claims. The permission to amend should not have been granted. Skipping ahead to the end of that paragraph, the judge was, in my view, right to identify as decisive the question whether the proposed amendments, or any of them, arise out of the same facts, as there was already an issue. To put that to one side, the point that I take from this is the point that I've been trying to take from the other authorities. Again, here, the defendants plainly had a general limitation defence. In fact, it was their case on their general limitation defence that was the basis for showing an arguable limitation defence for the new claims. But the amendments weren't allowed. And again, this isn't a direct authority for my proposition, but again, in this court, in the Court of Appeal, if the judge's approach is correct, if the friends are correct, there would have been an analysis of whether that extra prejudice was in fact in play when there was a general limitation defence pleaded to the original claim form. This judgment and the finding in it is inconsistent with a requirement that a defendant has pleaded no limitation defence to the original claim form, such that relation back would cause him no prejudice. And I've made the point, if that were a requirement, the amendments adding the new claims would have been allowed in Ballinger. Going to Chandler and Brooke then, volume 2 of the Authorities Bundle, tab 27. I'll take this fairly quickly because the court's very familiar with this authority and we've already seen it referred to in the other cases. If you go please straight to page 772, that's actually, first of all, I accept that in this case there was no general limitation defence. I accept that here the points I've been making by reference to Ballinger and G4S don't arise. So I'm going straight to page 772. And what we can take from this judgment and its analysis of Welsh Development Agency. Paragraph 64. The Court of Appeal in Welsh Development Agency endorsed the approach to new claims which don't rise out of similar facts. The Court of Appeal held that where it was arguable that a new claim was statute barred, leave to amend should not be given. The plaintiff should not gain the benefit of relation back under section 35(1). On the other hand, if the plaintiff could show the defendant did not have a reasonably arguable limitation defence, which was prejudiced by the operation of section 35(1), the court may give leave to amend. And skipping 65, we've seen the reference to the guidance in WDA remaining effective, the very last line of that page. In my submission, that's because, but primarily because, the court was anxious to show that there'd be no change in approach between the rules of these senior courts and the CPR. I shan't read the rest of those paragraphs because we've seen them in the other judgments. All I can take from Chandra is the point I've already made in response to Lord Justice Nugee's question, which was...
Sorry, go on. Complete what you're saying and then I'll just ask you a point on this.
Which is that if this requirement for prejudice were part of the test, I can put it no higher. In my submission, one would expect to see that box being ticked in this analysis.
What about
We've
the
seen it referenced in the test which is being applied.
what about the last main sentence of paragraph 64? If the plaintiff could show that the defendant did not have a reasonably arguable limitation defence which would be prejudiced by the operation of section 35(1), then the court would give leave.
Indeed. And one sees that reference, which will be prejudiced in many of these authorities. In my submission, the answer I gave to Justice Nugee earlier, that is a reference to the prejudice that may arise whenever limitation is an issue. Because in any case where limitation is an issue, there is the possibility that the court will settle on a limitation date, which is not that pleaded by the parties, and which may well fall between the date of the original claim form and the date of the amendment.
I mean, supposing that there is no question of an intermediate date, there is simply a plea that the whole claim is time barred because the cause of action accrued before any relevant date, then looking at that sentence, the operation of section 35(1) wouldn't prejudice anybody, and you would give leave.
The problem I know with that is that if one focuses only on the plea, one cannot cover all the possibilities that might arise, the potential that might arise that would prejudice the defendant.
Well, this isn't framed in terms of a plea. This says if the plaintiff can show that the defendant doesn't have a reasonably arguable limitation defence.
Oh yes.
So supposing that that were the case, supposing in this case that the claimants could show that relation back would make no difference, then on the face of it you wouldn't be prejudiced by the operation of section 35(1), and it's all right.
The difficulty is on a summary basis, how is it possible to show that relation back will make no difference to the defendants? One can only look at the pleadings, and the pleadings do not encompass every possibility that the court may ultimately arrive at a trial.
Well, it may do. I mean, I was thinking, I gave the example earlier, but a simpler example might be where there's some foreign limitation defence, and it's agreed that the foreign limitation will be applied under the Foreign Limitation Periods Act. But there's a dispute between the experts instructed on both sides, and one says under Brazilian law, this will be characterised as a tortious claim for which the time limit is 3 years, and the other one says no, under Brazilian law, this will be characterised as a contractual claim for which the time limit is 2 years. And those are the only options in play. And everybody accepts, both on the pleadings and as a matter of the evidence, those are the only options in play. You could have a claim form that's issued less than 3 years but more than 2 years, and amended less than 3 years but more than 2 years after the relevant date, and then you really couldn't have a possibility of the court coming to some intermediate position at trial because it's got to choose between A or B. But as I understand it, you say that in such a case you would still refuse the amendment.
Indeed, because the risk is still there, even if that's the plead. Well, there are two answers. First of all, as a matter of general principle, the risk is always there. One can never contemplate every possibility.
Is that which I'm querying, whether the risk is always there. I entirely see that if it's a question of when you could reasonably discover something, there could be a period, and it could be very difficult at the interlocutory stage to know where the court might end up. But if the real choice is between date A and date B, and there really is, nobody's suggesting that it could be anything other than those two, what's the risk?
So, as I say, I think there are three answers. First of all, three submissions that I make, two of which I think are answers. The first is the rule is of general application, and I accept there may be extreme cases where it is possible to see, even at the interlocutory stage, that there is no conceivable possibility of prejudice at all. But in order for the rule to be effective and to avoid many trials, some injustice in the broad sense may have to be done in order for it to work and for the thing to be effective on a summary basis, because of the very serious implications of relation back, the strict approach that we are asked to take in the language of section 35(3). The second point is that in reality, those cases are very rare. for limitation to be so clear at the interlocutory stage, and so that risk should not trouble the court unduly. But I fully accept the first point creates the possibility for injustice. And the third point, of course, is that in this case, if prejudice is defined as I'm defining it, which is that where limitation is an issue, unless you can show extreme facts as such described by Lord Nugee, then the amendment should be disallowed.
Can I just unpack it a little bit? I mean, in terms of your absolute general principle, forget about whether there's any prospect of relation back operating to a claimant, a defendant's disadvantage. Aside from the fact that there doesn't seem to be a particularly good reason for such a rule, it doesn't fit very well with that sentence, which refers to section 35(1) operating to somebody's prejudice. Is that right?
Yes, I had to go back to section 35(3) and say that in terms of construing the application, one was to ask what is necessary to give effect to that statutory provision. And certainly the reading of it is that it contains a very clear prohibition, and there's no scope in it for the kind of, I would say, large exception which the learned judge is coming in. But I fully accept that the first of my 3 points sits very uncomfortably with that reference to prejudice in WDA and in the other authorities.
So then moving on, and I know you haven't quite got to this part of your case, but you say, well, really, you can't generally at least eliminate the possibility of relation back operating to a defendant's disadvantage where there is a general limitation defence. Now, here, what's talked about is the plaintiff showing that the defendant doesn't have a reasonably arguable limitation defence. Now, why shouldn't one approach it in that sort of way? I mean, there can then be debate as to the extent to which what is pleaded by the defendant matters, the extent to which the overall pleadings matter, or the extent to which you look beyond the pleadings to the facts and the evidence. But why shouldn't one ask, is there a reasonably arguable limitation defence that is going to be prejudiced by relation back?
That was, as the court has seen, that is my fallback. But it has to be that broad question, not focused only on whether or not the defendant has pleaded a general limitation defence.
Yeah, I follow. So you say, well, look beyond the pleadings. But once you've looked beyond the pleadings, you look at what reason there is to suppose that there could be a limitation defence that would be prejudiced.
Yes, in the sense that unless one has a situation like Lord, just to be clear, unless one has a situation like Lord Justice Nugee, where it is crystal clear, it conceded for all purposes that this is the only possible outcome at trial, once limitations in issue, one has to accept that there may be prejudice to the defendant because the court may settle on a point between the defendant's pleaded case and the claimant's pleaded case. The burden being on the claimant to show that that's not arguably possible. I'm conscious of time. This is very useful to have the debate, and it allows me to focus on what is interesting to the court, but I do need to move on because I need to deal with ground 2 as well.
Yes.
WDA at Redpath is the next authority, and that's in volume 2, tab 17. And my point here is that I fully accept the passages in it which we've been debating need to be addressed, but one has to examine more closely as to whether it really is authority for the extreme proposition upheld by the learned judge. I'd ask the court to go to page 284H.
So which page?
Page 584. Page 584. Here, this is the reference to the first instance judgment of Judge Hicks, where he identified that these were new claims. Very bottom of 584, little Roman 7. The amendment should only be allowed if the defendant could not reasonably argue that the relevant period of limitation expired. If you go please to 588H, page 588. H. Once he's again, I'll skip over this fairly quickly, much of this text you've seen. The question is whether section 35.1 may deprive the defendant, at the very bottom of the page, of a limitation defence he would otherwise have. The possibility that he could be prejudiced. And then over the page, we see a reference to Leicester Wholesale Fruit Market in Grundy. And these are the passages that you've already seen. And in particular, a reference to Leicester Wholesale Fruit Market in Grundy, and the passage which is relied on me most strongly and upon which the judge placed great reliance. Because in Leicester Wholesale Food Market, there was also an amendment to the writ, and the amendment was opposed, although not on the same basis, not on the basis that the amendment should be disallowed. Glidewell, Lord Glidewell, page 111, gives the following passage between C and D. That if at a time when a further defendant is added to an action by amendment, he has a limitation defence, which he could raise if the plaintiff had then issued a new writ against him, if that defence would not have been available to the defendant at the time when the writ was originally issued, he should not be joined as defendant because he would thus be deprived of a defence which would then have been available to him. That makes the very point which I'm facing. He went on to say, however, that there was no evidence in that case that if the claim was statute barred when the writ was amended to add the additional defendants, it was not so barred when the writ was originally issued. In other words, the issue between the parties was whether the cause of action had arisen over 6 years before the date when the writ was originally issued, or on a much more recent date, as a statement of claim alleged. And then Lord Glidewell said, of course, if the second is correct, there's no question of limitation. If the first is correct, there would have been a limitation defence if Ham had been a party from the start. And Lord Glidewell himself, referring to himself, says, he didn't say in terms, but it's thus apparent that in that case, section 35.1 gave no advantage to the plaintiffs. He concluded, and I entirely accept that that passage is against me on the face of it, but his conclusion from Leicester Wholesale Fruit Market, page 113, repeats the orthodox approach. If at the time when the writ was amended, the plaintiff had instead issued a fresh writ against the same defendant, where that defendant had successfully applied to strike out the action on the ground the limitation period had expired. And then this, and the action was thus an abuse of the process of the court. I make a relatively limited point, but I do make it, that the focus in Leicester Wholesale Fruit Market here was on whether there was an abuse of the process of the court. It wasn't on exactly the same terms as our case. If the answer to that question is no, I can see no reason why exactly the same result should not be achieved by amending the writ to add the defendant as a defendant instead of issuing a new piece of paper. In my view, the test should be the same. And over the page of page 590, we'll see Lord Justice Glidewell approving a different judgment. He goes over the page and says, in the present case, this is page 590b, Judge Hicks appreciated that in Leicester Wholesale Fruit Market, on the facts referred to above, section 35.1 of the Act gave no advantage to the plaintiff. He therefore indicated he would have adopted the test applied in that case if the circumstances had been similar. Unfortunately, the judgment in Leicester Wholesale Fruit Market created confusion by saying that a passage in the judgment of Lord Justice Purchase in the earlier decision of this court in Grimsby Cold Stores was both overture and wrong. In that case, Lord Justice Purchase said leave to add a new party should not be given unless it can be shown that the defendant did not have a reasonably arguable case on limitation to be purchased by the additional new claim. I agree with Lord Justice Watkins that as a result of the new evidence, the appellants have at least a strong arguable case that the damage was suffered more than 6 years before the date of the application to amend, and that the application should not be granted. And then in prejudice, the applicant plaintiff can be mitigated if it exists by having recourse to issuing a fresh writ. In the present case, Judge Hicks correctly said that the Grimsby cold store case was on its own facts, a case to which Section 35(1) did apply so as to give an advantage to the plaintiff. The judge treated Lord Justice remarks about judgment in Grimsby as overture. He was too polite also to say he was wrong. Then Lord Justice Glidewell goes on to say he wants to make it clear that although the test applied in Leicester Wholesale Fruit Market and Grundy was the correct test in the circumstances of that case, where there was no advantage, it was unnecessary for the decision in that case to disagree with Lord Justice Purchase in Grimsby. On our view, Judge Hicks was correct in concluding that where Section 35(1) does or may well give the plaintiff an advantage, a different test, namely that enunciated by Lord Justice Purchase in the Grimsby cold store case, should be applied. In such a case, leave to amend by adding a new claim should not be given unless the plaintiff can show that the defendant does not have a reasonably arguable case for limitation. And so, with that, we go to see the Grimsby cold store case and ask.
That seems to be dead against you, and it seems to be accepting that there will be some cases where there's no prejudice because it's already expired, or if it's either already expired or there's no issue, and therefore there's no need to refuse the amendment, which is contrary to your principal case.
Yes.
And none of the other cases, I mean, could they qualify this decision? I mean, wouldn't this decision be binding on them, which makes me think that the other later cases which we start with are dealing with their own facts, and they don't intervene because of a potential risk which is not necessarily knowable. Once you've got over the hurdle of having some limitation bar you refuse the amendment. But this is actually looking at a much more nuanced case of you have to see whether or not there is an inverted commas problem. And if there is a problem, how you get to it, your second case is another thing, then we'll have to see whether we should refuse the amendment, which is what they seem to be saying when they say there's no reasonably arguable limitation case on those facts which create the potential problem.
I entirely see the difficulty this creates for my primary case, the principal case that in all circumstances one simply disallows where limitations an issue.
Yeah.
But I do rely on it as opposing the judge's strict position, which is one asks only if there is a general limitation defence.
I understand that. That's your second. As I've said a couple of times, I do understand your second case. It'd be quite interesting to see what the facts are that we're allowed to look at and which we can look at for your second case. But we're still arguing the first general case where you seem to say once there's a general defence, because of a potential risk that something might come out of the woodwork and be a defence at a different date, you refuse the amendment because you can do so on the general defence, and that's also all the problems about something coming out of the woodwork later. That seems to be how you're putting the first case.
Yes, well, sorry.
And that seems to be contrary to what this is doing.
Well, naturally,
saying.
Grimsby cold store.
Yeah.
I entirely accept that on what we've seen here, the reference to that analysis which appeared in Leicester Wholesale Fruit Market, but the judge also approves the Grimsby cold store case as a case where Section 35(1) does create prejudice. And that judgment is also not in the authorities bundle. I have to give you a copy of it. It's the fifth of Lord Sedley's rules about documents.
Any relevant case won't be there.
I don't know. What are the others?
Well, there are too many to list. The fifth is that none of the most relevant authorities are in the bundle. None of those rules reflect well on council.
Do you know where we find them?
There's Lord Sedley's rules. Google. It's that famous, my lord. Type in Lord Justice Sedley's rules on documents. That's the first thing you'll see. So the page. So in this case, in Grimsby Coal Stores, to give you advance warning, the defendants did advance a general limitation defence, and they were contending that the original writ was time barred. And we begin with the judgment of Lord Justice Watkins. Page 1 refers to the fact that the defendants were appealing against the decision of Lawson, sitting as a deputy judge of the High Court, where the judge had given the plaintiffs leave to amend by adding the new defendant. And if you go please to page 3, the defendants put an issue that about halfway down the third paragraph, or this is that second main paragraph. The defendants put an issue the damage alleged by the plaintiffs. They also maintain that the plaintiff's causes of action did not arise within 6 years of the commencement of proceedings and are accordingly barred by virtue of sections 2 and 5 of the Limitation Act. So here we have a general limitation defence to the original claim form. Bottom of that page 3, the objection to the proposed amendments is plainly based on limitation. The action was commenced by writ in September 1982, and over the page, if the proposed amendments are allowed, it may severely prejudice the defendants. This is the first paragraph, because this is about 4 lines down. They will lose the benefit of any limitation defence which may have accrued between 1982 and 1984. Stay on page 5 now. There's a reference to section 35. The second half of that page is section 35 of the Limitation Act. And over the page 6, a reference to the effect of section 35 in the first main paragraph. I'll have to move quickly through it. Page 7, the middle of the page, the appellants argued that the first plaintiffs were in a hopeless position, seeing as they had to concede that any damage they relied on must have occurred before October 1975. And the court will recall that the original writ was issued in 1982, September 1982. Thus, the relevant period limitation ended as long ago as October 1981. So they were plainly stating a general limitation defence to the original claim form. Over the page 8.
Just before, I mean, the Lord Justice Watkins goes on, that argument seems to be irresistibly right unless the plaintiffs could bring themselves within the terms of Order 20, Rule 5.
Indeed, my Lord, and that's what has become Rule 17.4 of
Yes.
the CPR.
But that's in relation to what he calls the first plaintiffs, and that's not pursued. You see that at the top of the page. So he then goes on to the second plaintiffs, which
Yeah, so the second plaintiffs.
Yes, that's it.
Sorry. But over page 8, I now turn to the claim of the second plaintiffs, in relation to which different considerations obtain. The respondents assert rightly that the essential question is whether the relevant period of limitation had expired at the date of the application to amend the rates. They argue they have used ample evidence supporting the balanced probabilities, the proposition that the cause of action didn't accrue before October 1978. Then further down the page, however, the indications at the middle of the last paragraph, the indications that the damage relied upon by the plaintiffs occurred more than 6 years before amendment were allowed to the writ are, I think, on the evidence before us, impressive. And then this, it may be that when the action is eventually fully heard, some different conclusion will be made out. But as matters stand, I think the judge was seriously in error in finding there was no justification for saying the material damage to either coal store 1 or 2 had occurred at a time more than 6 years before, as he put it, the issue of the writ. Indications I refer to point so strongly in the other direction, I would allow the appeal in relation to the second plaintiffs also. And that reference to when the action is eventually fully heard acknowledges in my submission the range of possibilities may ultimately, the range of possibilities that exist and upon which the court may ultimately settle in determining when the relevant damage took place, and therefore the final limitation position.
But this again seems to be looking at whether on the particulars damage occurred. It does seem still to be looking, doesn't it, at the particular fact in the case or the particular pleadings in the case to see whether or not there's a reasonable case for saying the original claim was within a right of time.
Indeed, and
I don't see how it helps us to qualify what was said in the one that we just looked at, the Welsh Development Agency case.
now look at the next judgment, Lord Justice Purchase. This is not going to give you the answer that you're looking for, but just to complete the picture, here Lord Justice Purchase makes it even clearer. The writ was issued on the 17th September 1982. Just above the first hole punch, the amendments sought the application were new claims within section 35(3). He's looked at the evidence, and last sentence of that paragraph, the report indicates a strong probability that damage to the coal stores must have been recognised or capable of recognition before October 1975. So again, he's making plain that by the time of the original writ, time had expired, arguably. Over the page, Mr. Crowther submitted my view rightly. The court should be careful to avoid the evil which section 35(3) was passed to prevent, namely prejudice to defendants losing protection from the Limitation Act by reference back the date of the original writ of any new claim which might otherwise be added. Leave to add a new party should not be given unless it can be shown that the defendant didn't have a reasonably arguable case on limitation which would be prejudiced by the additional new claim. And he agrees with Justice Watkins that as a result of the new evidence, the appellants had a strong arguable case that the damage was suffered more than 6 years before the date of the application to amend, and the application should not have been granted. And the prejudice the plaintiffs can be mitigated by them issuing a fresh writ. If there is a defence of limitation which has arisen since the date of the original writ but before the application for leave to amend, the defendants will have been prejudiced to the extent of something like 2 years, the period during which the defence under the statute of limitations would not be available to them because of the operation of relation back. So again, here we have, and my notes can see, emphasising authorities and points which are relevant not to my first point, but to my second, that there's a general limitation defence. In analysing prejudice, it's not determinative that if they're right about their original, their defence of limitation to the original writ, the amendment causes no prejudice. On the contrary, the defendants are relying on the arguments they have for their limitation defence of the original writ to say why the amendments are also time barred and shouldn't be allowed. And that is it on the authorities. And so I have to come back to the question put to me now a few times by Mr. Lewis. And the answer is, on the point of principle, notwithstanding, and this is, I can say no more than this, notwithstanding the passages that we've seen in WDA and Leicester Fruit Market, when the test has been restated subsequently, the analysis of whether particular prejudice has been caused has formed no part of the test, which is why, presumably, it has not appeared in the White Book. In my submission, when the word prejudice is used in the authorities which follow, it is the prejudice that arises in every case where limitation is raised, the prejudice which potentially arises in every case where limitation is raised, which is why the court, in my submission, should take a strict approach notwithstanding the risk that there will be extreme cases such as those identified by Justice Nugee. But my fallback position is that prejudice means the risk that the court will settle on a limitation period, which will create a disadvantage for the defendant by operation of relation back. And that analysis of potential prejudice is not limited to the defendant's own pleadings, and in particular, a general limitation plea that the original claim form is time barred.
Are we going to see what the parties' rival contentions as to a limitation period in this case are?
Yes, but I can be brief.
It's presumably common ground that it's Brazilian law of limitation. But
Brazilian law is the limitation, is the law governing limitation common ground. Our primary case is that all the claims are time barred. We have a general limitation defence.
Yes, but what is your case? Is it that under the Brazilian law of limitation, this is a tort and the time period is 3 years, or?
It's common ground, my lord, that Brazilian law applies, subject to an amendment which the claimants have put forward on Friday, which is why I have the Latin Marshall application. It's a common ground that the starting point is that it's common ground that it's a tort in Brazilian law, and it's common ground that the starting point is a 3-year limitation period under the Brazilian Civil Code.
3 years from when?
3 years
From when?
from damage,
Damage.
subject to questions of knowledge. And in rules very similar to our section 32(1)(b), there is a question in Brazilian law disputed between the parties as to the requisite level of knowledge for the time period to begin, and whether that's constructive or actual knowledge. And that very question is an issue between the parties. So we have the equivalent of a section 32(1)(b) dispute between us in this case.
Is it section 32(1)(b) or section 14(a)?
No,
Do you have to show deliberate concealment?
Sorry, under Brazilian law,
I presume.
I'm drawing a rough comparison between what is our rule under section 32(1)(b). I'm simply trying to give you an idea of what the
Yes,
the Brazilian
but,
law
we have two rules post-payment. We have section 14(a) for
Yes.
tortious claims, where you don't need to show that the defendant's done anything particularly wrong. You just need to show you didn't know about it.
Indeed.
And we have section 32, which does require deliberate concealment or deliberate commission or whatever.
The position under Brazilian law is not directly analogous to either of those. That is all disputed between us, and that's a matter that I've gone as far as I can on common ground. But the question of knowledge, constructive or actual knowledge, is definitely an issue between us, and that is material to when time begins to run. In Brazil, as you know, this cartel, alleged cartel, was the subject of a great deal of publicity and regulatory
I don't
activity.
think you should assume that we know anything, well, speaking for myself, know anything about the underlying facts.
I'll come to that. I'll come to that.
We do need to know the facts and the dates. I mean, if you're wrong on your point 1, but even on your point 1, we have to have an understanding of the dates and what your pleadings say, don't we?
Well, we have pleaded a general limitation defence, and the claimants have pleaded that there are cases entirely in time.
Mm-hmm.
And in their, I'll show you the pleading. I'll show you the claimants' reply. I don't need to show you our defence because we simply said, by reference to Brazilian law, these claims are all at the time. But the claimant's reply in the core bundle, tab 27. The reply behind tab 27 and page 476, the very back of the document. Sorry, I missed.
Just to remind me, what are the relevant dates? When was the claim issued? Or the claims?
May I actually take you back to the chronology? It's on tab 24. Tab 24, the same core bundle. That's on page 375. And one sees, and this is an agreed document, the very, very first item on the chronology is the administrative proceedings brought against Suco Citrico Cutrale, which is the defendant's company. The company is no longer a party to the action because the court found a favourable jurisdiction application in respect to the company. In 1995, cease and desist agreements were entered into. Sorry, 1994. Yes, in 1995, cease and desist agreements were entered into in respect to the administrative proceedings. In 1999, further proceedings were begun. Then this, in January 2006, the public authority performed a dawn raid, the headquarters of the processing companies, Operation Fanta. This is coming around a highly publicised public dawn raid in relation to the alleged orange juice cartel, including the headquarters of Suco Citrico. The Brazilian Competition Authority in 2006 added the first and second defendant to the administrative proceedings. And in 2016, the Administrative Tribunal ratified the TCCs in relation to the 1999 administrative proceedings. But those TCCs had been entered into, obviously, several years previously. Then we see in 2016, the CADI decision to ratify the TCCs was published, and in 2019, very bottom of the page, the Viegas Claim was issued. Over the page. And since we're looking at this, you'll see that in Brazil also, in 2019, claims were issued by claimants in these proceedings against the same company, Suco Citrico, in Brazil. And was referred to in 2019 and 2020. And if you go to the bottom quarter of the page 376, you see that first instance judgments were made in Brazil in 2020, finding that the Brazilian claims were time barred, applying the 3-year limitation period. So, is that sufficient for the purposes of the background?
Which are the amendments which are in question? Are they the first set of amendments to the Viegas Claim form?
Yes, in 2019, yes, it's the third entry on page 376.
And the second set of amendments, or just the first?
Both.
So we're talking about the difference between the issue of the claim form at the end of September 2019 and the pre-service amendments made in January 2020. Is that right?
Yes.
Is there one paragraph in the master particular claim form which says they did terrible things to us during the following period?
Yes.
Which paragraph is that?
That's paragraph, actually, memory, paragraph 53 on page 401 of all the alleged terrible things dates Paragraph 2 of the particulars of claim gives you the defined period. That's on page 383. At the bottom of paragraph 2 on page 383, there's a period which the claimants call the admitted cartel period. We obviously dispute that, it's not admitted, but the period is from January 1999 to January 2006. That is the pleaded defined cartel period, the purpose of the claim. And the
So can I take it that the act occurred then, the damage occurred then,
yes,
subject to any knowledge and issue?
indeed, and indeed, my lord, yes. And for the purposes of knowledge, it is material to look at what my lord referred to as the bad conduct or alleged bad conduct on page 401. On page 401, we have the claimant's pleading, paragraph 53, which particularizes the alleged cartel conduct which took place between 1999 and 2006. And what I draw your attention to here is how much of this conduct was in the public domain or otherwise obviously known to the claimants.
What they say is they engaged in this conduct allegedly, at least during the admitted cartel period, which we've seen, was they reserve their position as to other periods pending disclosure.
Indeed. And so the alleged bad behaviour is also set out in paragraph 53, which goes right through to page 403, involving alleged conduct directly with the claimants, allegedly refusing to deal with claimants, forcing them to deal with other defendants, setting on economical prices, prejudicing their access to the orange production plants.
And in your defence in the next document, this is the easiest paragraph to say this is generally or in particular.
On page 462,
yeah,
limitation is pleaded in paragraph 74.
Yeah. I've marked this already, yeah. '75 is the date, and '76 is the relevant knowledge could be no later than February 26th.
Indeed.
2006.
Indeed, my lord, yes. And then the claimant's reply on behind tab 27. And you see at paragraph 27 their current pleading, where they say, paragraph 27 sub 1, currently at least, and I'll take you to their proposed amended pleading in a second. The limitation period did not start to run until at the earliest the date of publication of the final decision on the 6th of March 2018. Which is the earliest possible date in which they obtained the requisite unequivocal knowledge. And there's a question about what that means. That's a question of Brazilian law. And they also say the limitation period, 3 lines down, was restarted by the filing of protests for Brazilian civil procedure, which they say restarted the limitation period.
And which of the dates that we've now looked at, if the court finally settles on that, means that you lose a defence you'd otherwise have had because of the relation back period?
None of those particular dates of itself.
Right.
The point I've been making throughout the hearing so far is that we cannot know where the court will ultimately settle. In this case, it's a pleaded issue as to when the claimants had the requisite knowledge, the requisite, as claimants say, unequivocal knowledge, which caused the time period to begin.
But none of the pleadings in any of the particular claim, the defence or the reply, if those were the dates, you either would have your limitation defence or the amendment wouldn't matter because it would be within time on all the pleaded dates.
That's correct. That's correct. And the judge, that was the judge's point, that unless you can say on the face of the defendant's pleading that you would suffer prejudice if the amendments were allowed, notwithstanding your general limitation defence, you have suffered no prejudice within the meaning of the cases. And in my respectful submission, that was far too narrow because it ignored the risk of the prejudice arising because of a limitation period fixed by the court in the course of the proceedings.
I mean, I quite see if, in response to your pleading, there had been a pleading by the claimants, well, actually, relevant knowledge was acquired on, I'm forgetting my dates, the 1st of January 2017, then it would be quite odd if you simply looked at your defence, because then there would be clearly on the pleadings an issue as to whether a date between the date of issue and the date of the amendments mattered. It's a bit different here.
Except that the point of principle, which is not the first point of principle, the question of what does prejudice mean here cannot, we say, be identified solely by reference to the pleaded cases. That's the issue.
You say that even on these pleadings, a judge at trial might end up finding that the relevant 3-year period started running sometime between September 2016 and January 2017, and therefore it would make a difference.
Yes, indeed. And those, far from being a speculative consideration, that is squarely in the area where the claimants and the defendants are disagreeing. You see in their pleaded case, they say the latest is 2018, we say it's much earlier.
You say it's 2006.
Indeed, but
But your point is, it will be open to the court on those pleadings to select any date between the two dates.
of course, and if the court selects a date between the two dates, we will not be barred from taking advantage of that finding. It cannot be said that because we pleaded a general limitation defence, we cannot take advantage of a finding that limitation fell elsewhere.
So you say,
Part
well,
of the general case.
if you simply looked at the date of damage, then plainly it's time barred.
Yes.
The claimant's case, the claimant's case is when you don't stop with date of damage, you look at knowledge.
Yes,
And when you're dealing with knowledge, who's to say what the date's going to be?
indeed. And there's even more uncertainty than that, my lord, which is the Ladder Marshall point. Because on Friday evening, we received the further proposed particulars of claim. And we'd ask you to look at it dib in essay and then resolve whether we satisfy the Ladder Marshall principles.
I'm not sure it's even evidence. I mean, I can't.
No, I know.
I can't quite see why Ladder Marshall comes into it. It's just.
It was a debate we were having internally. I mean, I've certainly been in many cases where those documents have been brought along and the court has decided to look at them and decided what to do with them and give them such weight as you will give a proposed
Are you opposing
document.
us looking at them?
I'm so sorry?
Are you opposing us looking
Yes.
at them? In which case, why are you showing them to us?
I'm so sorry. So as our current position is, we are opposing the amendments,
Yes.
Yes,
but the reason I'm showing it to you is because it's evidence of what might happen. It's if the
you're not
amendments.
opposing us looking at them.
I'm so
You're,
sorry.
you're in favour of us looking at them. So the question
I
is whether Mr.
misunderstood.
Chu Choi objects to us looking at them.
Yes, he's well, no, that's wrong. He said you may look at them to bene esse, but he says they're irrelevant.
No, I quite follow. If they're irrelevant, then they won't help us. But is there any objection to us looking at them?
Well, wouldn't it?
No.
I misunderstood. No one objects to you looking at them. I thought the question was whether we were opposing the amendments themselves, and we are currently opposing them. The point is, if we fail, as we may, and they're allowed in, it makes it even clearer that the question of limitation is even less certain. And
You're not opposed to us looking at them. Can we see them?
yes, of course, you should have by now.
They'd already read them before.
And-
I even knew it
Where do I find it?
This was the bundle which my lords didn't have this morning. When
Oh,
I
I
was
see.
doing housekeeping.
Thank you.
I'm assuming Lord Lewis does not need.
Well, I'll have just in case the bundle you're now giving, that's different from the one I was sent, just in case. But I've been given a bundle like that.
It should be the same. So if you look please at the draft amended master particulars of claim first, and paragraph 2A on page 22. There's a new claim that the cartel period ran on until at least the 16th of August 2017. The damage, that is now alleged to have continued until August 2017. And the reply, the draft amended reply, should be behind tab 5 in your bundle, and you see how Brazilian limitation generally is addressed on page 64. And we see for the first time in paragraph 28 a plea that to the extent that any of the claims are found to be time barred under Brazilian law, the claimants will contend that section 1 of the Foreign Limitation Periods Act should be disapplied on the basis that its application would conflict with public policy and or cause undue hardship to applicable claimants.
What is the effect under the Act if you disapply a foreign limitation? Do you default to English limitation?
Yes.
Well, how's that going to help you? In the sense that if they're right, there's deliberate concealment, they can defeat an English limitation defence, and if they're wrong, they're time barred anyway.
But what it means is that, again, it shows how unsafe it was for the judge simply to rely on a pleaded limitation case in the case before her. In principle, simply saying, if the defendants plead a general limitation defence, or even the approach put to me by Lord Justice Newey, where you look strictly at the pleadings as they stand, that tells you once and for all whether the defendants will suffer prejudice or not if the amendments are allowed. Because one can have subsequently changes like these.
But I mean, there are two possible responses to that. One is the one you're suggesting, which is that the amendments to add new parties or new courses of action should be disallowed because of the potential for limitation being different when you get to trial from what it is now. The other possible way of dealing with that problem is to refuse this amendment on the basis that it will change the effect of the relation back, and therefore that's unfair.
But we have, for the purposes of your decision,
We'll have to assume that question is not before us.
indeed.
I mean, it does raise a wider point potentially. I mean, suppose in any case amendments are allowed on the basis that they don't raise a limitation period problem, and then the claimant applies to amend to introduce a new claim where relation back would have been significant. I mean, that's not a problem limited to this case, and one would think one has to address that by looking at what happens to the amendment rather than the mere possibility that somebody might one day apply to make an amendment that would raise the limitation issue.
I see that, but the basic point remains the same, which is that the judge's approach is to look only at what the defendant had pleaded, and where the defendant had pleaded general limitation defence, there's no prejudice within any of the cases. And my point to the judge and my point to my lords is that's far too narrow.
Nothing like so certain.
Indeed.
Yes.
And this is just a little example of how fluid.
But this is a different period, though. They'd be claiming for a continuation the periods of unlawful, alleged unlawful behaviour beyond that already added. So that doesn't really help. I mean, I don't see to this case. If you decide whether it's reasonably arguable by looking at the pleadings for one period, the fact that they might come along and say, well, there's a different period, a different alleged behaviour.
I see that it's not. I see that, my lord. But the point is, it just shows how things can change. It makes the point, which is obvious anyway, which is that their case on limitation can evolve. Again, the judge is considering the likelihood of prejudice with a 3-year limitation period. But if she's considering an English limitation period, again, sorry, not just our judge, but any judge, a wholly different limitation period could be in play at trial, and that might make a difference to whether the risk of prejudice is realistic or not, which is why it is.
So I then wonder why we've had 6 cases where we've struggled to work out what the facts were, where in each case the judgment should have been 1 paragraph. There is an arguable limitation defence here. Things could change, so we're not doing anything. We refuse the permission. That's all they would have to do. They're obviously struggling with something more than that, aren't they? More than the absolute. Once you've got a possible defence on limitation to something, just in case things change at trial or subsequently, let's not allow anything else. Let's make it absolutely, you must issue a new claim form. And that's not what the cases that you've shown us say.
With respect, that's obviously correct. The point I'm making by reference to these proposed amended pleadings is simply how fluid and uncertain the case is. And I'm doing that to address the point the judge made, and that very narrow focus, which, unless I've completely misunderstood, is not quite what's been put to me by my lord. You're putting to me a scenario where the court does need to look at the broader picture and should not be looking only at the defendants. I'm not saying it's my lord's view.
The starting point is it can't just be automatic once there is a limitation period defence, arguably if there's any limitation period defence, thereafter no amendment should be allowed, which is where we're really getting towards on your first.
That's the first case, yes.
The second case then is we've got to look at something.
Yes.
And one normally looks at the pleadings, that's the starting point.
Yes.
You work out what people are saying. I accept a slightly different of knowledge, but I thought, well, I've written down, I thought that when you look at all the different dates and permutations in the pleadings themselves, none of those would lead to a situation where relation back created difficulties, or to use the words in the case law, prejudice. So now we're moving on to something different, which is twofold. One, life is complicated, and goodness knows what the judge is going to do. She may decide a completely different date, which nobody had foreshadowed. Or 2, further amendments might be made to change the date. And we mustn't assume that those wouldn't be granted. And because we can't assume that those wouldn't be granted, although they would be subject to the same set of arguments here, we ought to refuse any permission to amend in these types of cases. That seems to be where we're getting to.
Indeed. And as regards those last 2 points, my lord, the first of them, life is complicated. It's more than that. Once the limitation issues are pleaded, save for the very extreme cases that Lord Nugee identified to me, it is all up in the air. And that's not just, that's not an incident or a corollary effect. That is the inevitable result of limitation issues being raised, save for the cases which Lord Nugee did put to. And so once those are an issue in that way, that is the prejudice. Because it means that whatever happens at trial is neither here nor there. The defendant has lost the opportunity to take advantage of a limitation point in relation to the amendments which are allowed. That's, on this case, that is the prejudice. And these pleadings simply show how little certainty a judge can have in looking at the pleadings. I fully take the point that one starts with the pleadings and one has to place some reliance on them because that crystallizes the case so the courts can determine issues before them. But it shows how fluid the questions for trial may be on questions of limitation. I'm told that they foreshadowed the pleading amendments going to the later period in the original draft of the particulars of claim. I think my lord's picked up on that point, that Lord Lewis pointed out that although the pleaded claim period was...
They reserved their rights.
They reserved their rights, indeed. That was before the judge. And I'm asked to give you a reference to our skeleton in paragraph 48, but not to take you to it. So I'll give you the reference and move on in view of the time. I think it's the time that's worrying my genius. Just to get my bearings.
So is that really as far as we can go on the substance, or is there more? Because obviously you need to deal with the question of implied sanction.
That, as far as I'm concerned, those are my submissions. I'll just check to make sure I've not missed anything. So I'll move on then to my second ground of appeal and relief from sanctions.
Yeah.
Because of course, this is a steep slope for me, because even if you're with me on ground one, I can only succeed if you're with me on ground two also, because the judge found that in any event, the defendant's application to allow the claimants, disallow the claimant's amendments was out of time. As the court knows, Rule 17.2 sub 2 provides that such an application must be made within 14 days, and the judge refused relief from sanctions. We make two points in our appeal against that finding. First, we say that relief from sanctions wasn't required at all because properly interpreted, the defendants did not miss that deadline. Because we submit that where a defendant challenges the jurisdiction of the court, there is an implied extension to 14 days following the final resolution of the jurisdiction challenge. And that's because any application under Rule 17.22 could amount to a voluntary submission to the jurisdiction. And the civil procedure rules must allow a defendant to preserve his ability to seek to strike out an amendment under Rule 17.22 while allowing him to pursue a jurisdiction application. So we say that 14-day time limit is extended by implication until the resolution of any such jurisdiction challenge. And our strikeout applications were brought within 14 days of the final resolution of our respective jurisdiction challenges. So, on the first of those points, the
How
learned
do you
judge,
know when it's finally resolved?
well, when your final appeal has been, when your final, when the point is no longer an issue, when you have run out of road, when the appeal is finally resolved against you or you have failed.
So if Justice Henshaw decides against you, plainly you have 21 days to put in an application for permission to appeal. But even if you miss that deadline, you could potentially get an extension of time. I mean, there isn't a clear date.
Yeah, so we worked on the basis of when acknowledgements of service were required under the court order. So, and it's in our skeleton argument, my lord. We addressed this point by reference to the acknowledgements of service and their dates and the dates by which we brought the applications. And those dates themselves are not in dispute. So if we're right that there was a 14-day extension from the resolution of the jurisdiction challenges, then we are in time.
Yeah.
The judge disagreed, as my lords have seen, because she said we could have made any strikeout application within the 14 days without prejudice to our jurisdiction challenge. But saying, this is my submission, saying on its face that a strikeout application is without prejudice to a jurisdiction challenge does not give a defendant complete security. And on the authorities making or even threatening to make a strikeout application can amount to a voluntary submission to the jurisdiction. And if I take you first, just
Even if you say, we're only doing this to preserve our position, we won't pursue it unless the jurisdiction challenge fails.
yes, indeed, and that's we thought at least fairly well understood. But the authorities are still useful for the court, and I'd ask you to look at a textbook first for the overview, and then I'll go to the cases. Grant on civil fraud, please, is in volume 4 of the authorities, tab 63. Page 1635. The very bottom of that page. In essence, a party will be deemed to have submitted to the jurisdiction of the English courts if he has taken some step which is only necessary or only useful if the objection relied upon has been waived or had never been entertained at all. And examples of steps that have been held to amount to submission are, and I draw the court's attention in particular to sub 4, a applying or even threatening to apply to strike out. And the next authority I wish to take you to is global multimedia. Here I will be going in chronological order. I've got fewer authorities. Volume 2 is tab 63, tab 23. Global Multimedia International and our Media Services. Going please to page 699 and the judgment of Chancellor. Paragraph 1 tells you what this is about. An application for orders to extend time for making an application under Part 11, dispute the jurisdiction of the court, to try the Part 20 claim against them. And they oppose the application, and the respondents contend that the applicant has submitted the jurisdiction. Page 708, please. Paragraph 27. The test to be applied in determining whether any particular conduct amounts to a submission to jurisdiction is considered by Mr. Coleman in Progress Mining, and then skipping down to the indented passage beginning with G. In particular, he makes a voluntary submission to the jurisdiction if he takes a step in the proceedings, which in all the circumstances amounts to a recognition of the court's jurisdiction in respect to the claim, which is the subject matter of the proceedings. Skipping down 3 lines, whether any particular matter, for example, an application to the court, amounts to a voluntary submission to the jurisdiction must depend upon the circumstances of the particular case. And when one sees language like circumstances of the case, one sees right away one can never have complete certainty if that's an evaluative judgment which has to be taken in every case. And then at the bottom of the page, there'll be an effective waiver or submission only where the step relied upon as a waiver or submission cannot be explained except on the assumption that the party in question accepts that the court should be given jurisdiction. And then page 700.
The next sentence is interesting too. Particularly explained is necessary or useful for some purpose other than the acceptance of the jurisdiction.
There will on the authority be no submission. If the well-informed bystander had been left in doubt because what the defendants had done was equivocal, explicable on other grounds in addition to agreement to accept jurisdiction, and the conclusion must be there'd be no submission. So, to anticipate my Lord's question, our point is that where an application is made to strike out on the grounds that we've raised under 17.22, that is an unequivocal acceptance of the court's jurisdiction, and it's not done for any benefit linked to a jurisdiction challenge. And in any event, whether a particular application amounts to a voluntary submission, it depends on the circumstances of the particular case and involves an evaluative judgment, which generates real uncertainty for an applicant in view of the consequences of a submission. Page 710, paragraph 31. To any objective outside observer, the applicant's conduct was only consistent with an acceptance of jurisdiction. A defendant who intends to challenge the jurisdiction of the court, and then the court makes a list of the things you don't do when you are intending to challenge jurisdiction. And one of them, little e, nor does he threaten to strike out the claim if the claimant refuses to discontinue it. I'd ask you next to go please to Newland Shipping and Forwarding Limited in the 3rd volume of authorities, tab 37. Judgment of Sarah Cockrell, QCHE then was. I take you to it because it's useful summary of the preceding authorities, and page 909, we'll see it's a dual application for relief from sanctions under CPR 3.9 and a jurisdiction application under CPR Rule Part 11. And how it arose, one sees it page 912, paragraph 15. One point with which I should deal here is that the fifth defendant doesn't make any discrete application to set aside the default judgment against him. The reasons for the approach are being debated, and the fifth defendant says it's simply in order to avoid any risk of submission to the jurisdiction. Logically, in order to have the default judgment set aside, the fifth defendant would be acknowledging the jurisdiction of the court, which he disputes, and he would be asking it to rule on merits. The only step which he can safely take is one which he has taken, to acknowledge service solely for the purpose of disputing jurisdiction and disputing jurisdiction accordingly. Skipping down to 18, the judge says, while I can appreciate that from the claimant's perspective, the lack of challenge to the default judgment may seem anomalous. I consider the claimant's argument does not really bite. I do not accept the argument that the fifth defendant is making the wrong application. The authorities, including the excerpts from Briggs and Dicey, make clear the very great degree of caution which a party who is challenging jurisdiction must exercise. The point appears to be open. Neither party referred to me as authority which deals with this point in terms. It certainly seems possible that an argument challenging the default judgment in partnership with the jurisdiction challenge, so even in partnership with the jurisdiction challenge, might be said to amount to submission to the jurisdiction in circumstances where the authorities tend to suggest that taking any step in relation to the merits of the claim can amount to a submission. Citing global media, multimedia, and then skipping ahead, accordingly, it seems to me the fifth defendant was entitled to form the view that it was unsafe to apply to set aside the default judgment now, and the course of action taken cannot fairly be described as wrong. On the contrary, challenging jurisdiction was logically the first step, whether or not it might have been combined with a very cautiously worded challenge to the default judgment. And we rely on that and we make the same point. It was highly unsafe in our case to seek to strike out the addition of the new claimants under Rule 17.2. And that's because the question of whether the defendants have an arguable limitation defence does involve and would have involved issues relating to the merits. The defendants would have needed to take a positive position on limitation, which normally means filing a defence. And in asking if the defendants have an arguable limitation defence, the court would need to consider when the claimants had sufficient knowledge of the alleged wrongdoing to be able to bring the claim, not to determine it outright, but to ask if the limitation defence is arguable. And for the purposes of this strikeout application before the learned judge, the question of whether the defendants had an arguable limitation defence under Brazilian law was not conceded by the claimants until skeleton arguments. We had both served letters from Brazilian law experts. That issue was contested until shortly before the hearing for the purposes of the defendant's Rule 17.22 application. And that would have involved a debate about the merits of the underlying case. Now the learned judge relied on PGSC Bank in Chicago, which I'd ask you to look at now in the third volume of authorities, around tab 43. In particular, the judgment of the Chancellor. If you go please to paragraph 57, which is on page 1139, just to see the heading, that has the fifth defendant submitted to the jurisdiction, and then page 1142, paragraph 66, this is the test. I'll go through paragraph 66. The Chancellor refers to the test formulated by Mr. Justice Patton, who then was in Snay Investments. The conduct must be a wholly unequivocal submission to the jurisdiction. And the Chancellor says that's a more succinct and modern statement of the older tests expressed in greater length. Wholly unequivocal submission. And if a party makes a strikeout application to the English court, there is a good argument that it can only be necessary or useful if the court has jurisdiction. And that is the test applied in the indented passage over the page. The relevant test is whether the party has, by its conduct in the proceeding, acted in such a way which is only necessary or only useful if objection to the jurisdiction of the court has been waived or not entertained at all. But, and this is the passage Clare made against me, paragraph 67. The Chancellor said, the issue of an application to strike out the claim at the same time as an application to challenge the jurisdiction cannot conceivably be described as only necessary or only useful if the objection to jurisdiction made in the application is clearly, if the objection to jurisdiction is made in the same application and is clearly not being abandoned. Putting it another way, where both applications are being made, the fifth defendant's conduct is at best equivocal. Whilst he could have made it absolutely clear by expressly stating in the application notice the application to strike out was without prejudice to his challenge to the jurisdiction, the fact that he did not do so does not make his conduct wholly unequivocal. Now, the language of cannot conceivably, that making an application which assumes that the court has jurisdiction at the same time as jurisdiction challenge, saying that cannot conceivably be described as satisfying the test for submission is a good deal stronger than we have seen in the other cases. And saying that where one puts a written caveat saying that the applications without prejudice jurisdiction makes it absolutely clear is likewise a good deal stronger than we've seen in the other authorities. And that formulation by the Chancellor is not reflected in the academic texts. It's never been suggested that these formula of words or steps give the applicant complete protection against a later finding that they had thereby submitted. And so one hesitates to point to this passage as an example of a legal rule that would give a defendant complete protection from a later finding of submission. It may be that the courts are increasingly willing to give defendants that protection, but that is a modern development, not a guarantee. And there are real practical difficulties which the Chancellor may not have had taken to him in bringing, actually wouldn't have been relevant to the Chancellor, so he didn't need to look at it, but if one looks at 17.22 applications and jurisdiction applications, there is a real practical difficulty in bringing them at the same time. Because a heavy jurisdiction application cannot normally be brought in any practical sense within 14 days. And an application for an extension of time for a 17.22 application would itself run into the problems of submitting to the jurisdiction. It would be made independently of any jurisdiction challenge. And just looking at the chronology that we looked at earlier, you go back to that please in the core bundle. That's in tab 24 of the chronology. You see the situation that we were in. You go to page 376, please. You see that the acknowledgements of service were filed in February 2020. And that's just at the first hole punch. But the jurisdiction application was brought in June 2020. And that was...
Is there not a time limit for bringing the jurisdiction challenge?
Indeed, my lord, and as is very common in the commercial court, the time was extended consensually precisely because, and the reason why these extensions are consented to is because the court would give them otherwise, because a heavy jurisdiction application cannot be done normally in the time in the rules. And for example, our jurisdiction application here, and ours wasn't special, this is a common situation required analysis of forum non-conveniens and the quality of justice available in Brazil.
Don't you tick a box on the acknowledgement of service saying I intend to contest jurisdiction?
Yes.
So it's in play from the or should be in play from the acknowledgement of service.
Yes, it is. But the point that the Chancellor was addressing was if the application to if the application accepting the jurisdiction of the court is made at the same time as a jurisdiction challenge, it seemed that he was making the point that the applications are being run in parallel. One can tick that box and not actually take a jurisdiction challenge. Ultimately, that is not a guarantee the jurisdiction challenge will be taken.
Does that extend the 14 days? If you tick the box and you spend a little while, you get consensual amendment, and then you decide not to tick it, it doesn't make the 14 days a problem. You've still extended it, have you? This is the implied exception for the 14 days, and the 17-1 will apply once you signal an intention whether or not you...
Yes, indeed. Once the box is ticked, 14 days runs from the resolution of the jurisdiction application, which could be not change your mind. The date upon which you have not made, by the date by which you've missed the time to make your jurisdiction application under the rules, or pursuant to whatever has been agreed to the parties or ordered by the court.
So the 14 days runs what, from notification that you're no longer intending to pursue it?
Yes, because that is a resolution of the jurisdiction challenge. Once the box is ticked, the assumption is made that jurisdiction will be challenged. But that still has a time limit. There's always a time limit running from ticking the box, the rules of the court, or any consensual extension. And that is how one orientates the resolution of the jurisdiction issue. And 14 days runs from that.
No, because that's what I just asked. I mean, the consensual thing, you could have brought it by the 5th of May 2024, but I was asking if you decided on the 1st of May that in fact you weren't going to go ahead with it, and you notified them on the 1st of May, the 14 days would run from then, not from the last date of any court order agreeing it.
My Lord, that's why I said...
There's uncertainty, obviously, if this is what it is, and I'm just testing whether or not there's an implied exception, depending on whether or not the time runs from when you decide or unilaterally give notification that you're not now pursuing a jurisdiction application which you were previously going to do.
But there's no more uncertainty than arises whenever the parties agree a consensual extension. It has to be done by reference to a court order. If we're asking the court to extend time, it still requires an order. The parties,
I understand the court order fixing time. This is a different problem. Before that time expires, and when you would still have time to make it,
yes, I see.
You decide as a matter of unilateral choice not to make it.
Yes.
And I was asking whether the time then ran from unilateral notification or unilateral decision not to make it, and that's a different one.
Indeed, my Lord, I see that, and that's something we haven't addressed at all yet. Sorry. So there is obviously a degree of uncertainty in that scenario, but it would be open to the other side to say that a 17.22 application would be out of time, because if the deadline for jurisdiction has expired, then once there's an argument that the deadline for taking the jurisdiction point has expired, the applicant for the 17.22 application is at risk. But I fully accept that if internally the applicant decides not to take the jurisdiction point and there's still a few days left on the agreement, that may grant an extra few days grace to the applicant intending to make.
If you're talking about implied exceptions to the CPR rules, worth testing what that exception is, because the more difficult it is to frame it, the less likely it is that there is such an exception.
That degree of the uncertainty that introduces,
as you say, minimal,
is really minimal, and it's far better to have that minimal uncertainty and create a situation of far greater harm, which is that parties are forced to issue 17.22 applications submit to jurisdiction irrevocably, and in the particular circumstance of their case.
I mean, of course, it could be framed slightly differently. You say, well, the time limit on jurisdiction applications isn't a problem because although you start with 14 days, you can get an extension commonly by consent and necessary by going to the court. Well, couldn't that be said about 17.2 as well?
The problem there is that if you go to the court and ask for an extension for 17.22, because you are considering, because you're still within time to make a jurisdiction application, it might well be said that that is a submission to jurisdiction. The application for an extension of time for the 17.22 application could itself be a submission, because that is a step in the proceedings.
Yes, I see.
And what Sarah Cockrell QC is sitting as the Deputy Judge of the High Court and the authorities tell us is that utmost caution is required to avoid submission, which is why we say the rules should have implicitly a 14-day extension from the resolution of any such jurisdiction challenge or the right to bring such a challenge.
We've hit 1 o'clock. I think originally you were due to sit down at this point. You have yet to deal with implied sanction.
Yes. I will try and cut back. It's a much shorter point than the one we've been debating in ground one. I haven't got a clear idea now of how long I'll take because I will try and cut back on my submissions. But we're not in a timing crisis, if that's the court's concern. I'm sure
Mr. Chu Choi might have a different view.
you can be reassured that I warned him and his team this morning that I may go past lunch. This issue, grounds 1 and 2, concerns far more claimants, concerns over 1,300 claimants, so it's actually an important point. So I'd rather take a bit more time on it and take the time out of my response to his appeal. We will still have equal time and finish on time.
Okay, we'll see how we go. 2 o'clock.
Court rise and table.